We need to be good at sussing out.
You can do it from any point.
Let's collaborate instead of compete.
What's up, everybody? Welcome back to the Mentor Nation podcast. I'm your host, John Abbas. And if this is your first time here, do me a favor, take 2 seconds, hit that subscribe button so that you get notified every time I release a new episode. If you're coming back, welcome back. Thank you so much for your time and your attention. And I promise you, today's guest will not disappoint. So, and it's kind of crazy, but dying obviously isn't something that any of us want to think about. But after today's guest, you will understand why you absolutely need a plan in case the unfortunate happens. I was utterly shocked at just how high the percentage is of people who never take the time in their life to put a plan together so that their money and their family is protected in case something unforeseen happens to you. Brad Barth is the absolute expert and guru when it comes to estate planning. Brad is the founder and senior managing partner of BarthCalderon LLP, is the co-author of the book Planning Today for All of Your Tomorrows. I think that's a pretty clever name, actually. But in this episode, Brad covers literally everything that you need to know about how, why, and when to put together an estate plan. I honestly learned so much from this interview that I've already listened to it 3 times. I went back and I took a bunch of notes, and I was shocked at how much I didn't know. And I started implementing some of the things he said right away. So I know you're going to love this. Get out a pen and paper and enjoy the show. All right, Brad. All right, we're recording. Thank you so much for being on the Mentor Nation podcast. Glad to have you on. I'm excited for our conversation today.
Great. Thanks, Sean. Pleasure to be here.
Yeah, absolutely. So before we begin, I just wanted to see if you could really quickly, because you're great at what you do and you've been doing it a very long time. I just want to see if you could introduce yourself to everybody and just explain a little bit about yourself and what you do.
Sure. So my name is Brad Barth. I'm a partner of a firm called BarthCalderon. We're located in Orange County, California. I got started with the firm back in 1997. My father is the senior partner and managing partner of the firm, and I am his junior partner and been with him for, like I said, about 25 years or so. The firm has its origination. My father was one of the very first financial planners, certified financial planners, CFPs, in the country back in the late 70s. And so as he was progressing through his financial practice, he realized that there was a major legal component involved in his financial practice. And he was always referring business out to attorneys. And you know what? My dad doesn't like attorneys. So he said, you know what, rather than just giving the business away, I'm going to go off and be a lawyer myself. So as a result, we've kind of integrated the financial planning practice into a law firm. So every individual through their practice, financial, you have risk management, you have financial portfolio diversification, you have insurance planning, you have estate planning, retirement planning, income tax minimization planning. These are all the things that kind of make up comprehensive financial plans. But now you have to take a look at it. What about the legal components behind that? What about the business organizational structures? What about the legal structuring for your retirement or for your business practice? And so my father, over the last, let's say 30 some odd years, has really kind of developed the firm to kind of fit that mold. We fill a gap. We aren't so much a litigation-based firm. We're not the guys that you see on TV that are chasing ambulances. We're pretty much on the other side of that.
Yeah.
Business owners, as you know, have risk. No matter what you do, and especially in California and other areas around the country, you got products, the stream of commerce, you got employees, you got regulations, product defects, human error. And so what we try to do is try to situate our clients so that their business is in the best position to be able to withstand a tax creditor wise. And those can be blindsided relationships. It can be unknown items, such as maybe a business partner passes away. It could be the world's largest and most aggressive creditor, the IRS on the back end, making sure you have a successful succession plan for your company, because that could be a massive devastation on most of our clients' largest assets. So it's through that genesis of my father's financial background, kind of rolling it over to a law firm, which is kind of how that firm got its start. And so we kind of fill that very nice space, and we do it in what I consider a very nice way, an ethical way, because we're not the people out there trying to tear people apart. We're
Yep.
trying to protect and bring things and build things together with our clients, which gives me a lot of satisfaction. I do for a living. So thank you.
That's awesome. And I specifically wanted to chat today about like estate planning, things like that, because I was listening to you in another interview and just hearing you talk. I just can't tell you how important I think this is for everyone. Probably maybe a little more important for the wealthier you are, the more assets that you have. But
Mhm.
man, for everybody, like my dad didn't have a ton, but he passed 4 years ago. And as soon as he passed, like it wasn't a day later, my stepmom, who I don't love, just went crazy. It was just like the only thing that mattered was hoarding assets and
Yep.
everything that he had. And I had a guy here installing photos in our home today. His mom just passed away, and all he was talking is so ironic that we have this talk today because he was just talking about how he was stressed out because his siblings are just fighting over possessions. And so my hope today is that we can deliver an estate planning 101 masterclass,
Mm-hmm.
and so the listeners just have an idea of what they need to think about. And
Mm-hmm.
then maybe we'll mix it with any stories that come to mind or
Sure.
just some craziness that you've seen in your almost 30 years of doing
Yeah,
this.
you bet. You bet. And I'll tell you, just kind of commenting on your opening statement there, is that, you know, I want to say that what you're experiencing, unfortunately, it's not unusual. It normally happens. And with that, estate planning certainly helps. It certainly gives a roadmap. It certainly can help mitigate some of the challenges between survivors, especially in situations like yours where you may have a blended family. It's all the more so complicated. But understand that I think it's a good statement overall, is that you don't want to oversell what the estate plan, what it does. It's like
Right.
any other type of a guide or a roadmap, but you're still dealing with the human component. You still got people involved, and unfortunately, you're dealing sometimes with people at their worst. Right? They've lost a loved one.
Sure.
They're stressed out. They feel very vulnerable. Maybe someone's a little bit elderly. Maybe they start getting a little bit paranoid. People are kind of coming in. They're dealing with situations. They don't know what's going on. Maybe the surviving spouse or partner really wasn't involved in the finances. So I think probably the best overall lesson that someone can take away from this talk is that working with professionals in any area of your life, whether it's a mentor, spiritually, personally, professionally, having someone that does this type of work to kind of guide someone through the process, not only on the pre-planning phases, but in situations like yours, even on the post-planning phases, is incredibly important, because sometimes you have to wrangle the personalities so that the documents can do what they're intended to do. Right. So I totally feel what you're saying. I don't want to say that it's an unsuccessful plan if there was a plan, because even well thought out plans, you still have the human component there. But I think that thankfully, I think the substantial majority of what we deal with are successes, right? They little bit of housekeeping, a little bit of tutoring, and things kind of move along pretty well. But not to say that you don't have conflict. It's a part of the business.
Gotcha. And I actually also wanted to cover pre-planning as well. And when I was listening to you talk, you had talked about 3 major components to a comprehensive believing. Please correct me if I'm wrong on any of this,
That's
but
right. No.
I would love to have you elaborate a little on each one, why they're important, from the power of attorney to the living will to
Perfect.
post.
Yep.
So please feel free, take it away.
Okay, sure, you got it. So when you're dealing with an estate plan, people always have in their mind, oh, the will, right? Because for most people and that don't do this for a living, they just see things like on TV or novels that they all get together in the lawyer's room and then they have the reading of the will. But the will actually in a comprehensive modern estate plan is actually a relatively minor player. You're right. There are 3 main tiers, 3 main components of an estate plan. And it just has to do with timeline. The first tier, the first set are your powers of attorney. And most people are familiar with this. These are durable powers of attorney for financial management and what we call in California the Advanced Healthcare Directive. In other states, it's called a durable power of attorney for healthcare. And so here, what you're doing is nobody has passed away yet, right? So no one's passed away. So this is not about disposing of assets for the benefit of a beneficiary. This is where, John, you or I, as a principal, as an individual, simply can no longer make decisions for ourselves for whatever reason. It can be something that's maybe it's a car accident, God forbid. Maybe it's some type of medical condition that happened where we are just unable to manage our own affairs. So you look at that from a financial point of view. I mean, you're running a business, I'm running a business. There may come a point in time where we can't run the business, but the business is a going concern. So someone can step into our shoes and make those decisions for us. We call them documents of substituted judgment. Somebody is substituting their judgment for yours, but they're doing it on your behalf in what's called the fiduciary capacity. So someone needs to pay the mortgage, someone has to run or sell the business, somebody has to file your taxes for you, somebody has to deal with the lawyers to kind of help on your behalf to do whatever. So someone needs to do that. That's a very important document. And reason why I always start off with this is because when most people think about estate planning or reading of the will, they think of them purely as death documents. I died, someone gets my stuff, and that's the end of it. But if you understand how the process goes, most times when somebody passes away, the administration of an estate plan is wrapped up, that is start to finish, or at least start to autopilot. How about that? Will be about 18 months. It takes some time, 18 months to say to 2 years, to kind of muster up the assets, identify the liabilities, identify the beneficiaries, set up accountings, and kind of make distributions or set up accounts for minors, etc. That takes between a year and a half to 2 years on an average basis. But let's say, John, you and I we're roughly about the same age. God forbid you and I get into a car accident. Now we may be incapacitated, not for 18 months, but for 18 years, right? So no one's dead yet, right? But we need someone now to act on our behalf, file our taxes, go with access to our bank accounts, and deal with our retirement plans. So these documents are extremely important, because it's not just who gets your stuff when you die, John, who takes care of you when you cannot take care of yourself. So that's on the financial side. And when you're a business owner, it's even all the more so important, because guess what? Sometimes when you appoint what the most people, I'm sure like you, just like me, I'll appoint my spouse, right? So if I'm unable to do my thing, I'll go ahead and appoint my wife. Honey, you're the best person. You manage everything. But guess what? My wife doesn't know the first darn thing about running a law firm. Guess what? She isn't even a lawyer. So she can't even run a law firm. So I may have to have somebody regarding a particular asset. We call that a limited power of attorney for business affairs. But my wife will do everything else, right? So for many of my business owners, not only do you have your general power of attorney for financial management, you may have a standalone, set aside, limited power of attorney to manage the business affairs. Okay, so we actually identify which ones they are, and that because they maybe your CFO, maybe your COO, maybe your business partner, they themselves are the best people to manage that, where your spouse is better for everything else. So you got to kind of think these things through. So there, you got to kind of know who the client is. And in the exact same vein, you now have the financial side, you have the healthcare side, right? So who makes medical decisions for you? You can no longer represent yourself. Who says that making that you're going to consent to that particular procedure? You're going to consent to organ donation. You're going to consent to that particular long-term care facility, right? So, or as you mentioned, the living will, not last will. In California, it's integrated. That's what most people refer to as the pull the plug provision, right? Pull the plug.
Right.
So that is actually integrated into the California Advanced Healthcare Directive, which basically says like this, that if you're in a medically determined irreversible coma, right, you ain't coming out, right, or you're in a persistent vegetative state, you're effectively brain dead, and all that you're doing is artificially delaying the moment of someone's passing. But for the human intervention, your body would have naturally passed away in a month, a week, or whatever. For financial purposes and even for emotional purposes, there may become a point in time where, you know something, why don't you just remove that human intervention and let your body do what it's going to do? That needs to be in writing. As I mentioned, in California, that's already part of our advanced healthcare directive. But for your audience members who are not in California, other states call that a living will. Again, not a last will. That's different. But that kind of falls in those categories of documents of incapacity, financial incapacity, business incapacity, medical incapacity, and sometimes end of life, pull the plug documents as well. That's all kind of fall under that first tier. So before I go on, do you have any questions?
Yeah. So I just want to reiterate this because this is what I took from it when I listened to you the first time in another interview. I'm just like, as an entrepreneur myself, I'm like, holy shit, man. I haven't made any of these decisions. Like if I were to get into a car accident or a plane crash or something were to happen, like I have assets spread all over the place and nobody in the world knows where they all are.
Right.
I have nobody that is other than my wife, perhaps by default, that's there to make any decisions for anything. I have no directive on what I think I have the organ donation thing on my driver's license, and that's it. Like it's like I don't have any of this. And so I want the listeners to really grasp this and listen to what you're saying, because and I want to get into, like how they do that, what's the simple way, like what age, like did you recommend for people like as early as possible, as soon as they know about it? I want to get into all that, but I just wanted to reiterate what you've already said and why these things are critical, because most people, it's like life insurance, right? They just don't want to think about it. And it's like, just because you don't think about it doesn't mean you're immune from something bad happening to you. And it's when it becomes messy. So I just wanted to reiterate as you move forward. So
great. Yeah, and I just make a note to come back on the, how much should I have? How old should I be? Because I want to make sure that I cover that when I get done with at least kind of covering the other two components that we have remaining. Now, the next component, as we kind of talked about, was powers of attorney. You mentioned it, a will, and then you have like your living trust. So the next document, again, a relatively minor player, which may be relatively surprising for people, is that last will. And this is where a lot of people kind of are surprised. Wait a second, I thought that was like the key document, but actually in a comprehensive plan, it's not. A will does two major things in a modern plan. The first thing that it does, it typically nominates the guardians for your minor children. So if you have minor children and you are incapacitated, again, unavailable, or you pass away, you're going to nominate people to be that legal guardian of your minor children. And minors typically are under the age of 18. So once you hit 18, you're no longer are deemed a minor, so the guardianship wouldn't be relevant. But if you're under the age of 18 and mom and dad aren't available, or your current legal guardian is unavailable, you want to have a series of successors. And the reason why you want to take an affirmative step on that is because there actually is an order of priority that's built into almost every state's law. It's called the probate code in most states. There is an order, and they want to go most close degree relative, mom, dad, sister, brother, aunt, uncle, niece, nephew. They try to stay in that order. But you know something, your sister or your brother may not be the right person for whatever reasons. Maybe you got different socioeconomic backgrounds. Maybe you have different religious backgrounds. Maybe you have different geographical locations, or you just don't have a good relationship with you don't like the way they're raising their kids. So, in order to make that affirmative decision, again, you got to put that stuff down in writing. And to your point on life insurance, John, I'll make a comment on that because it kind of ties into guardianship, and I'll just use myself as an example. I have 4 kids, as I told you before we came online, and my sister has 2 of her own kids. So as you would think, just for discussion purposes, I list my sister Amy as the guardian of my children. Well, my sister Amy has 2 kids. God forbid my wife and I pass away. Now I list my sister as my guardian. I now have 4 kids that I have to plopping into her household. Well, my sister Amy is already, with her own struggles and challenges that all young families have, all this has her own economic challenges, and all of a sudden I want to drop 4 more kids on her, and that I mean, my kids are already an economic hardship on me, and now they're going to be an even greater economic hardship on my sister, who's already struggling. And so my sister can always say no, right? I mean, she may say yes
Yeah.
out of obligation and familiar obligation, but you know what? The people that you list as guardian, it's a nomination. It's not an appointment. It's a nomination. And so now, if, however, John, to your point about life insurance, for those of us who don't have an estate, you ain't got
Yep.
millions of dollars floating around, we need to create that estate. And the way that you create that estate is through life insurance. So now I go to my sister. Now I go to my sister. Hey, Amy, I got 4 kids. And guess what? I have $4 million coming along with them. Now, all of a sudden, that economic hardship factor goes away because I want my sister. I chose her as my number one. I
Right.
want to give her all the help I can to support my kids. But that brings up another good point. I'll give my kids to my sister. The question, John, is will I give $4 million to my sister? And the answer is no, right? I call my sister golden heart, empty head, right? I love her. I never give her my checkbook, right? Right? So now you have to tie in who's the financial guardian. You have a guardian of the person, but what about guardian of the money that comes along? And that may or may not be the same person. I just gave you an example of why it's not the same person. So you gotta think this through. So that's one of the main things that a will does for you. It nominates those guardians, take an active role, and there's a series of decisions and options you have within that. And then the next main thing that a will does for you, these are called pour over wills, like you're pouring over a glass. Pour, P-O-U-R, pour over wills.
Yep.
Because normally you have a trust, which we'll talk about next. But in a trust, one of the main benefits for a lot of our clients, especially nowadays, because the estate tax environment is so high, estate taxes are not really an issue for a lot of people. Hopefully it stays that way, depending upon future administrations. But estate tax is not a problem for a lot of people. So the two main things that trusts give you are orderly distribution of the assets for the benefit of the family, and they give you probate avoidance. So you get to avoid probate. But probate avoidance only occurs in your trust so long as the trust is funded. And what do I mean by funding? I mean that you have think of your trust as just a box, a shoebox. You gotta put your stuff in the box. Right?
That's right.
Nobody goes to Nordstrom's and spends $300 on a pair of shoes and walks out with an empty box.
That's exactly
you
right.
Typically want the shoes either on your feet or in the box, right? When you walk out the store, right? So if you go to your lawyer and you're walking out with an empty box, that means you may have a trust, but you didn't avoid probate because you didn't fill the box up. So now you have this box. You spent all this time explaining what do you want to have happen to your assets when you pass away, but the assets are not in the box, the governing document. So how do we get the assets in the box? Well, ideally, when you leave your lawyer or shortly after working with your wealth team, you fill the box up, you put the shoes in the box. But if you don't and you fail and you pass away, or maybe you acquire an asset in the future that was not in the box, it happens all the time, those assets go to probate. Now they look at your will. This is the second thing your will does for you. They look at your will and they say, listen, the will says, Your Honor, when I pass away, any probate assets, any assets subject to probate administration, I want you to pour those into my trust. I don't want the court to administer it. I want it to be governed by my shoebox. And so that's the next main thing. So the two main components of a will are guardian and pour over. So as you can see, it's an important document, but it's not what you see on TV where it's the reading of the will and everyone's sitting on the table and who gets what. That's not it, right? So
Brewster's Millions. I don't know if you've ever seen. Yeah, that's anytime I think of a will, that's the movie that comes to mind.
Yeah.
So I do have a couple questions because, funny enough, me and my wife were on a plane going to Iceland, and we hit insane turbulence. And once it calmed down, we were just like, I don't know how we got on the conversation, but we looked at each other and we were like, where would our daughter go if we both actually died? And I wanted to ask you, because I still don't know, like, We have
Yeah.
lots of different relatives. We still actually don't have a perfect person in mind,
Yep.
but I just like, what's your experience like? How do they
Yeah.
determine who the closest next of kin is? Like, do you know?
Yeah, typically it's going to be any adult sibling. So that's going to be if you have like I have 4 kids. So right now 2 of my kids are adults and 2 of them are minors.
Okay.
So if most likely my minors would go to my adult daughter, because that would be like order number 1. Any adult siblings among the kids themselves.
Right.
If not, if they're probably going to go to any aunts or parents, grandparents, of course. Grandparents will be probably next in line. And then if no grandparents are around, or the grandparents are just too old and don't want the job, it's going to go to aunts and uncles, right? Aunts and
Gotcha.
uncles. And then if there's no aunts and uncles and you have adult and nieces and nephews, it may go that way, or cousins, it may go that way as well. So that's kind of the general order of things. But I'll give you a scenario that actually came up with me and a client down in San Diego, where there was a tragic accident, and there was some minors that were involved. I think the kids at the time were like 7 and 5 years old.
Mhm.
And then the estate plan, without much thought, they just listed the sister, right? The sister. And the sister happened to live up in Kalispell, Montana, which, if you know the area, I think it's called the Glacier Park. That's kind of up where it is on the border of Montana and Canada. So you couldn't think of a more contrasting environment from sunny San Diego on the beach to Kalispell, Montana in Glacial Park. So now, and then they had completely different backgrounds. I mean, other than the sister relationship and the aunt relationship, different socioeconomics, different religious environment, different geographical environments, different socioeconomics. And so what happened now is that you took the kids who were 7 and 5 years old, who had their own school friends and support team. They were part of the Boy Scouts and Girl Scouts support team. They're members of the church organization. They had they lost mom and dad. And now what happened? You plucked them up and you moved them over to Kalispell. And now they lost their entire support structure as well, because they simply didn't give it any thought. So to answer your question, it isn't always your sister. It isn't always mom and dad. Sometimes it's your best friend. It's the people you go to church with. It's the people you hang out with. It's the people that your kids and their kids are at the Memorial Day barbecue every year. That may be the best person as guardian.
That's it. That's godfather, godmother. I mean, that's exactly
right.
That's it for us, right? Like we have somebody that we trust, not related by any form, but she can't have kids, always wanted them, and she's just a mentor to us. So that really, really, really was helpful. So okay, now we can get back on track. I just had that question. I was really curious about that.
No, just bring them on, right? So now we have tier number 3. So you went powers of attorney, will, and now you have trust. This is your third component, your trust. And most people have heard of the term a trust, a living trust, a revocable trust. So what is this thing? I already kind of mentioned it in the previous discussion about the shoebox.
Yep.
And all you got to think about is the shoebox. It's like where it's you basically put a box together that is a paper representation of you. And so you got this box, and the box has, and this is what I told you earlier about the roadmap. Remember about the roadmap? Yep. The box is your roadmap. So you take the time and you spell out who's going to be in charge of the assets when mom and dad pass away, who are going to be the beneficiaries when mom and dad pass away, how are they going to receive those assets when mom and dad pass away. Okay, are there going to be outright distributions? Are there going to be cascaded distributions? Are there going to be incentive provisions? Is who's going to be the one in charge? Uncle Bob? Is it going to be a bank? Is it going to be a professional? Are we worried about not your kids? What about your in-laws or the outlaws? About the relationship? Like I love my daughter, my son-in-law, not so much. I want to make sure that my inheritance stays with my daughter.
Yeah.
I don't care about their divorces. I don't care about his overbearing pressures on my daughter. My inheritance is for her, and it stays with her regardless of what happens in their relationship. So you got to think about these things. But wait a second, is my daughter a spendthrift? Does my daughter have drug and alcohol problems? Does my daughter have special needs requirements? So you got to think about not only who the beneficiaries are, how they receive, and who's the best person to administer all this. So that's what the magic shoebox does. And you got to fill that shoebox up with your house, your bank account, your brokerage accounts, the beneficiaries to life insurance policies and other types of assets, your business, your stock, your LLC membership interest, your real estate has to be inside there. If you have notes and promissory notes, you got to have it's all got to be put inside the shoebox. And then if it's in the shoebox, on top of all the other organizational and asset protection and dispositionary provisions, you're now also getting probate avoidance, right? And if you have one asset that's left outside, remember, pour over will get it inside there, right?
Got it.
That's how it all ties together.
Quick question. Did you ever, I don't know if you read, about this, but I read a while ago, and I don't know if you've heard of it. There was that billionaire, centimillionaire that left his entire fortune to I think it was 5 generations down.
Mm-hmm.
Yep. Nothing to his kids, grandkids. He's and their statement was, I just want to make sure that it's far enough down that and this was maybe 150 years ago. And so it became a story because we're now at a time when the great kids were going to get the money. Do you remember that story?
No, I haven't, but I very easily can imagine it though. So those are we call those dynasty trusts, right? Because you're making a dynasty. And so just to get a little technical on it, it's a great segue because it kind of goes into some of the taxation issues. Perfect. So what happens is, and most people know this, that you are subject to taxation. So in America, we don't tax the right to receive an inheritance. We don't tax the right to receive a gift. What we do is we tax the person who's leaving the inheritance. We're taxing the decedent. We're taxing the person who's giving the asset, not the beneficiary. So here we have an exemption. It's called the estate tax exemption. And right now, it happens to be a very, very high number, the highest we've ever seen in the history of the country, which is a carryover from the Trump administration. Now, not to make this a political discussion, but the current administration is simply just trying to lower that exemption amount because the more money that's subject to tax, and it's a 40% tax, the more money the government can take away from you from your lifelong earnings. So there actually is an attack on the multi-generational transfer of wealth in the present administration. So thankfully, we are still enjoying a very high exemption, $12 million. And if you're married, you can double it up, $24 million. So again, most people aren't subject to any taxation at all, but be careful of future administrations. They're trying to lower that threshold so they have a taxable estate. Now, why did I mention that? Because in your example about the 5 generations down, not only are you taxed at your generation. So think about this, John. You have $10 million.
Yep.
And you give it all to your kids. Now your kids have $10 million. And then the government comes in and changes the number. How about this? Let me change the facts a little bit. Let's say you have $20 million, just so we can kind of play it out. $20 million. And the exemption, again, just lawyer math, is $10 million. So you had 10 million got exempt, and you paid tax on the 5 that was, or the 10 that was outside the exemption. Okay, so you paid $5 million in tax. So now the kids have 15 million. The kids pass away, and now they get taxed again on the money that was already taxed. And then when they die, it gets taxed again to the great grandkids. So it's taxed upon tax upon tax. So someone got very clever and said, wait a second, what if I just skip my kids, because they don't need it, and I just go straight to my grandkids? I'm going to pass or skip a generation of estate taxes. That's called a generation skip, a generation transfer. And there's actually believe it or not, a punitive tax for doing so.
Oh my God.
But thankfully we do have an exemption on there. So for those of my clients, and we do this all the time, who want to create these multi-generational transfers, you just need to find the right tax exemption to use to fill it in. The government gives us the power to do so. It's not that the government is trying to be parasitic. They actually give us an option to do it. You just got to exercise it correctly. So you do have multi-generational. 5 tiers down sounds a little crazy. Most times you use it, and then it just kind of, as long as there's heirs, lineal descendants, and as long as there's assets, those things work. That it works. And that's how you have these huge family legacies like Kennedys and Fords and whatever's, over money upon money upon money, generation after generation, because somebody was clever enough and had good counsel that set something like this up. But you gotta be careful, right? It's like I call this don't try this at home, kids, right? You want to make sure that you file it correctly, right? Because you can mess it up on filings, right? So that's a good tactic. Because it does, you do want to there's nothing wrong with maximizing your tax advantages. There's nothing wrong
Absolutely.
with that. Right.
Absolutely. So going back to like, when should someone start? I mean,
Oh yeah, great.
I like, when, or is it a net worth thing? Like, when should people start thinking about this? What should they do first? Should they do it all together? Like, all the questions that I know the listeners are going to have, they're listening to this, and I know most of them are just like, holy shit, I need this. Now it's like, okay, when, where, how?
Okay, that's a great question, because I get this all the time. And people are like, I'm too young, I'm not married, I don't have any kids. What do I do? Okay, so first of all, let's just set the stage that I think everybody can agree that once you're an adult, you should at least have some kind of power of attorney. Okay, because remember, that had nothing to do with anyone dying. That had nothing to do with asset transfers. Everything to do with management if you can't do it for yourself. So when my kids became age 18, I created a power of attorney for them. First of all, one is off to university. I had to do it for myself. One of my daughters is going to school in Florida, so I have something over there in Florida. When my wife and I go out of town for a couple of weeks, and my child is with a friend of ours for 5 or 6 days, I give them a power of attorney over my son's healthcare. So you have to use the documents smartly. And even if you're not married, or you just have a significant other, maybe that person should have the power of attorney. Otherwise, you're going to wind up in a guardianship, a conservatorship, right? Now you're involved in probate. You got the court system. You got all kinds of crazy lawyers and fees and procedures have to go on. That doesn't go away. That's because, like you said, you got hit by a car, you're in a plane crash, God forbid. Unlikely you're going to survive that, but if you do, you could have challenges, mental challenges, right? So that's a baseline, right? I don't think, if you have assets, or even you're just an adult, or even if you're going to school, even for your babysitter or something, you may want to have some for cases of emergency. So there's some baseline stuff. Now, the next thing you want to take a look at, the next big one, is, do you have any children? Once you have kids, all right, people, it's time to adult up, right? It's time to just turn up the responsibility level, okay? Because it's no longer about you. And if you think about estate planning, John, the whole discussion here, it's not about you. Right? No one creates all these trusts and dynasties and generations and probate avoidances and minimizing taxes for your benefit, because you have to die for it to happen. Right? So it's never for you. It's always for your descendants. So once you have a child, even if you only have 2 nickels to rub together, you still need to have something to take care of that child. And that's where your life insurance kind of comes in big time on that. So that's a baseline for sure. And then the next thing is, if you have a couple of assets, if you have a business, if you have a house, if you have a portfolio over about $150,000, then basic stuff, you should have a basic plan. So I would kind of take them in that order. Even if you got nothing, but you're an adult, at least some financial and healthcare documents for you. If you have a kid, that's it. It's time to just level up, right? You got to just adult up. And then once you start actually having some assets, then for sure, because again, it's not for you. You have a responsibility, either to your lineal descendants, or if you're working so hard and you're accumulating something, make sure you pass that to your siblings or to a charity in a responsible fashion, and give direction, because all that you're doing is leaving a mess for people behind you. Right.
Yeah, that makes a lot of sense. So let's say you get this all set up. So I do have a question about your company. Like, do
Yep.
you work with anybody, everybody, certain net worth individuals?
Yep.
Like, do you have a recommendation? Like, what is your company
Sure.
specifically focused on?
Sure. So my firm, we have about 32 personnel altogether.
Mm,
12 to 15 of so are attorneys. And so it's not, you're not just looking at, I'm not BarthCalderon. I'm only one of the partners of BarthCalderon.
sure.
So there are, and thankfully we have a lot of associates that have been working with us for many, many years, and they work directly under our supervision when it comes to doing this type of estate plan. This stuff is not rocket science. There are some very important probing questions you have to ask, and there is a right way to do this, and there is the proper follow through. So if you have someone that's got a net worth of, let's say, $1 million or less, or maybe $2 million, okay, most likely they're going to be working with some of our associates. They may come through my channel, right? And I may assign them to one of my associates, but guess what? Ultimately, everything goes through my eyeballs, right? Because it's
Got it.
ultimately my name on the paper.
That's right.
So you still have the supervision that goes on, because where am I spending my time? I'm not spending my time so much on the $1 or $2 million net worth client. I'm with the 20, 30, 50, $60 million client, because
Absolutely.
it's more than just they need the basic plan too, but they need greater things. And that's just where my expertise kind of kicks in with those higher net worth individuals. So
Got it.
we take care of your mom and pop, and we take care of your what do you call it, your uber wealthy individuals as well, where it's
That's
about
awesome.
planning and estate minimization. And our firm is designed for that. As I told you before, we're financially is our background, right? We've derived from a financial background. So that's kind of what we do. That's our wheelhouse.
Yeah, and I think that's the perfect marriage, right?
Right.
Attorneys with certified or just financial
Right.
planners. Like, cause I can't tell you how many, like, they know one side, but not the other. Like,
Right.
that's genius what your father did. Like,
Right.
I think it's absolutely genius.
Yeah.
Now, my next question is, how often do you revisit your plan? Like, is it every time you acquire something, buy something, do something, change your mind about something, or is it like semi-annual? Like, kind of what's like your recommendation when somebody, let's say I go through your firm, we put everything together.
Mhm.
How often should I take a look at it?
Okay, so it's also another great question. So there is a at a minimum, okay. Um, I would say, how about this? At a maximum, no longer than 5 years. 5 years, kind of the magic
Okay.
number. So if you did something in 2022 and your life is completely boring and nothing has happened to you, and okay, 2027, been about 5 years, it's enough time. And I'll tell you the reasons why. The first thing is, most people, there are these big things that happen in life:
Yeah.
death, birth, marriage. You come into a lot of money, you lose a lot of money, you get married. Yeah, you no longer have the relationship with the people you had before. The kids who were minors are now adults, and you want them to play a role in this thing. The kids get married, you love your kid, you hate your in-law. Love your in-law, hate your kid, right? I mean, there's all kinds of different, so those are just your
Right.
life factors that go on. Now, the reason why I say 5 years is because if you think about it, every 4 years we have a new presidential election, and the government, both at a federal level and a state level, just can't keep their paws off of estate taxes. Dead people don't vote, and it's a great way of taking people's money away from them. So
Hmm.
there's also changes in the law, tax policies, laws. Our system that we have probably gets updated at least once or twice a month, just based upon case law. We download updates, because case law, maybe there's a language thing, maybe there was
Right.
a conflict, and so they needed to make the document a little bit more clearer. So even if your life is completely boring, at least every 5 years, because now you're just doing housekeeping. Right now, it's just a house. You want the document not to get stale. You want it to stay
Yep.
fresh. And here's the problem. Clients come to me all the time. I haven't seen my document since 1997. And it's like, it's 20 years old or whatever. It's like, you know something, John? That's actually worse than doing nothing, because
Huh.
what you planned 20 or 10 or 15 years ago has no relationship at all to
Yep.
what your situation is now. It would have been
Mm,
better if you did nothing, because at least now there's a natural progression of things based upon this state law. So you're actually in a worse position.
right.
You're rolling in your grave because this person's getting the assets and your kids got disinherited and you didn't take advantage of taxes because it got stale. So
Mm.
5 years really is the max that it should go.
That's a great answer. And I can only imagine, especially with what you talked about with new administrations, like, correct me if I'm wrong, but like with all of the baby boomers retiring, passing,
Yeah.
it's like one of the greatest transfers of wealth in
Yep.
history.
Yep.
And so I can imagine administrations are putting more priority than ever on changing these laws as fast
Yep.
as they possibly can.
Yep.
So that's great advice. So I think everybody has a really great grasp. My last couple of questions, just my first one is there anything that we didn't cover that you think would be important for the listeners to know? And then I have one more question after that.
Okay. So the answer to that question kind of ties into the reason why you're doing this podcast to begin with. It's the importance of having the plan. Okay.
Right.
As you know, I like to say, none of us get out of here alive. Right. So it's not like you're not going to have to face it. And
That's right.
when I have to sit down with clients across the table, and either it's a surviving spouse or the surviving kids, and we're looking at what's on the 4 sheets of paper or 4 corners of the document, or the lack of document, it results in either the good, the bad, or the ugly. And that is all a matter of what legacy that you left them. You can leave a legacy where things are organized and well thought out, or you can leave a legacy of chaos, which would cause conflict among the family members, and the money is long gone, and those
Right.
relationships are permanently rifted, and there ain't no looking back. Why? Because someone didn't take the affirmative steps of hiring a lawyer. Why? For $2,000-3,000, man? Are you kidding me?
Seriously.
That will pay dividends over and over and over in the
Right.
long run. So
Wow.
I think the biggest message is, and like I said, while you're doing this podcast, is informing people for the need to do estate planning. Statistically, only 30% of people have it. And I work with clients that have amazingly complicated business structures. They have every business contract under the sun that you can think of. They're multi-state, multinational, blah, blah, blah. You ask them for their estate plan. Oh,
Yeah.
I don't have one. Are you kidding me? Just look at the news. Michael Jackson, Prince. These are people that are worth millions and millions and have what to care about. No planning, right? Because I don't know. I don't know why that
Right.
is. So the biggest takeaway that I think that we just to put a cherry on it is just say, listen, you really need to move forward with this.
Awesome. I have one other question, and I typically only ask this to like doctors or soldiers, but I want to ask you as well, is like, is doing what you do for work, has it changed your perspective on like passing away? Has it made you
Yeah.
less afraid, more afraid, like just comical about it all? Like what's kind of, I felt like I wanted to ask you that.
Okay. Well, looking at me, you can tell I'm a religious guy. Okay. There's no question about that.
That's
Okay. So I think that goes without saying. There's reasons for that. When you're dealing with people at their worst a lot of
Yep.
times, and whether it's lawsuit based on businesses, it's incapacities, or somebody passing away, you deal with it often enough. You realize that we're all just a drop away from that moment, whatever that
That's right.
moment is.
That's
And
right.
so again, not to make this a spiritual discussion, but I definitely think that because I live in this world, and for 25 years I have thousands of clients, and I can tell you that there isn't a month, sometimes not a week, that goes by where somewhere along my client base somebody is passing away. So it makes the idea of the shortness, the brevity of life very real to me. And so you just
Right.
try to walk away and, lead the best life you can, try to
That's
make
right.
the place better as a result of you being here, be kind to your kids, be kind to people, be ethical in your business dealings, and ultimately be responsible about what you're doing and what you're leaving behind. And so I guess that's what's affected me, and it gives me great pride in doing what I do, because I know the benefit and happiness that I'm bringing to families. Yeah. So
That's
for sure.
awesome.
Yeah.
Well, I cannot tell you how much I appreciate
Right.
your knowledge, your time today. My final is just, if people wanted to touch base with your firm, follow you on social media, I'm going to put the links in the show notes, but
Right.
I just wanted to ask you, like, what's the best place for people to either follow what you're doing or to get in contact with you for services?
Right. So we have we actually have a business development portion. His name is Paul Hitchcock. He kind of works with us in our firm, and he
Awesome.
pretty much is in charge of that. I believe you may know who he is, and so I would say connect directly with Paul. And I don't like giving out my email directly, because
Of
all
course
I'm going to
not.
do is just push it over to Paul, because my calendar thankfully is impacted. I mean, that's a good thing. But it kind of helps to manage sometimes the workflow, because again, as I mentioned, it's not always me. So
That's right.
Paul and I can talk about how to kind of properly get the clients, or the prospect of clients, to the right professional. So the
Awesome.
best way is really to kind of work through our office, Paul
Awesome.
Hitchcock. And if in your show notes, if you typically he provides a text code or his email directly,
Cool.
that actually is the best way to get through to the firm and to me and to me.
Awesome. I'll put
Yeah.
that in the show notes. Brad, I
Good.
really appreciate you taking
Great.
the time to
Thank you.
explain this to everybody. I hope everybody understands how vital this is. And I'm excited to publish this as soon as possible. So thank you again for your time.
Thanks, John. My pleasure. Thanks.